Hello friend, how are you? I'm Advocate Gaurav Kumar Gupta, MBA Finance and Chartered Accountant qualified and PhD holder. आज हम एक्सप्लेन करने जा रहे हैं कुछ केस स्टडी कुछ जजमेंट के बारे में। आज आपको एक्सप्लेन कर रहे हैं। सुप्रीम कोर्ट ऑफ इंडिया स्टेट ऑफ एपी वर्सेस बीवी पांडुरंगा राव ऑन 4/2009 ऑथर ए पश्यावत बेंच अर्जित पश्यावत अशोक कुमार Ganguly reported. In the Supreme Court of India, Criminal Appellate Jurisdictions, Criminal Appeal Number 815 of 2003, State of AP, AP Appellant versus VV पांडुरंगा रॉय रिस्पॉन्डेंट। जजमेंट आया था, पांडुरंगा मुकदमा हुआ था, उसका जजमेंट आया था। डॉक्टर अरिजीत पश्यत जेड चैलेंज पहला आया था। चैलेंज इन दिस अपील इज टू द जजमेंट ऑफ ए डिवीजन बेंच ऑफ द आंध्र प्रदेश हाई कोर्ट डायरेक्टिंग एक्यूटल ऑफ द रिस्पोंडेंट हु फेस ट्रायल फॉर हैविंग allegedly committed the murder of his wife Viranki Bhulakshmi Viranki Bhulakshmi, hereinafter referred to as DGs. It was the prosecution case that after committing the murder of his wife, the accused had tried to commit suicide by cutting his throat with knife. Accused, he was charged for commission of offence punishable under Section 302 and 309 of the Indian Penal Code 1860, in short the IPC. Indian Penal Code. He was tried from both the offence, but he was sentenced only in respect of offence punishable under Section 302 IPC. Prosecution variation in a nutshell is follow. The accused, the DGs, and the prosecution witness were the resident of Bankura village of Vijayawada, Krishna district. The DGs The DGs was the wife of the accused. PW1 was the mother. PW2 and 3 were daughter, and PW4 was brother of the DGs. The DGs and PW2 were attending Koli work and were maintaining the family. They shifted their residence to Venkaru village for their livelihood and were staying in the house. PW1 of the intervening night of 2/3/2000 at about 3:45 am, the DG was sleeping on her cot in her house in Bankuru. The in Bankuru the in Bankuru the accused hacked her with a knife on her neck means garden, and caused her instantaneous death. Later, he attempted to commit suicide by cutting his throat prettily with a knife. PW1 woke up in the early hour and noticed that DGs were lying with the bleeding injury on her neck. The knife with blood was in the hand of the accused. Then, on saying PW1, the accused fled away. A complaint was lodged. It was the registered in CR number 48 of Tucson, the Penumbral Police Station. Inquest was held over the dead body of the DGs and the same was sent for post-mortem examination. PW8 में the medical officer conduct the autopsy and issue post-mortem certificate. The statements of the witness were recorded and investigation was undertaken. On compilation of investigation charge sheet was filed. As the accused person pleaded innocence, trial was held. As noted above, the trial court placed reliance on the evidence of Mother PW1 of the DGs and recorded conviction. The High Court found that the evidence of PW1 on whose evidence the conviction was recorded does not inspire means prerit karna, confidence. It was also noted that the report was given to the police officer on telephone as admitted by the brother of the deceased at about 4 a.m. The same does not appear to have been recorded in writing, and on the other hand, the police officer claimed to have come to the place occurrence of recorded the statement of the mother and converted into the FIR. The High Court noted that it was not explained by the investigating officer as to why the telephonic message was not reduced into writing. With reference to the evidence of PW1, the High Court noted that she stated that her son had informed the police. It is not known as to what the son of PW1 told the police, whether he told about the details of the crime, some crime had taken place. It is if it is former, then the message was required to be reduced in writing. The police officer who received the telephonic message is PW10. According to him, he received a telephonic message that some murder had taken place. He categorically admitted that they did not reduce the information into writing. Added to that, the High Court noted that the FIR reached the police station after about 7 hours. In the FIR is one noted the injury which were of the very serious nature on the person of the accused were not explained. It did not accept the stand taken. The accused tried to commit suicide. तीसरा पॉइंट में बता लर्न काउंसिल फॉर द एपिलांट स्टेट सबमिटेड that the reason recorded by the High Court to direct acquittal are not substantially in law. It is stated that the message the purported to have been given over telephone was the cryptic one of the therefore cannot be treated as a FIR. चौथा पॉइंट लर्न काउंसिल फॉर द रिस्पोंडेंट सपोर्टेड द जजमेंट ऑफ द हाई कोर्ट. 5 point certain facts have been rightly noted by the High Court where the information is only one which required the police to move the place of occurrence. As a matter of fact, the detailed statement was recorded after going to the place of occurrence. The said statement is to be treated as a FIR, but where some cryptic and anonymous oral message which did not in turn clearly specify a cognizable offense cannot be treated as FIR. The mere fact that the information was the first in point of time does not by itself cloth it with the character of FIR. The matter has to be considered in the background of section 154 and 162 the Code Criminal Procedure 77. In short, the code a cryptic telephonic message cognizable offense received by the police agency would not constitute a FIR. Sixth point, the object and purpose of giving a telephonic message is not to lodge the FIR but request the offer in charge of the police station to reach the place of occurrence. On the other hand, if the information given on telephone is not the cryptic on the basis that information the officer in charge in prima facie satisfied about the commission of a cognizable offense. Pursuits from the police station after the recording as such information to investigate such offense, then any statement made by any person in respect of the said offense, including detail about the participant, shall be deemed to be a statement made by a person to the police officer in the course of investigation covered by section 162 of code. A statement cannot be treated as FIR. To put it differently, any telephonic information about the commission of cognizable offense, irrespective of the nature, detail of such information cannot be treated as FIR. If in the instant case PW6 proceeded on the basis of what has been told by PW1 to him about the murder of the deceased, it was but natural that PW1 would have told him who the author of the crime was. That is not the case of prosecution. There has been lots of improvement in the evidence of PW, what she had made during investigation when compared with the recorded in court. 7 point. During investigation, PW1 had not stated that he had seen the accused standing near the dead body of the deceased, that on the hearing her cries her son Venkana, who has not been examined, came there and informed the incident to the police by phone. She had also not stated that the accused had told her that he had cut the throat of the deceased with a knife, which is available in the house. Interestingly, there was no effort made to match the blood group of the deceased with the blood found on the M01. If the aforesaid aspects are considered, the inevitable conclusion is that the appeal is without merit, deserve dismissal with which be direct. Dr. Ajit Pasyat, अशोक कुमार गांगली, न्यू दिल्ली, मई 4, 2009 का यह जजमेंट। डेट्स ऑल।